Because there's a rail strike that most people are now watching it. How do we know how many people are actually joining?
Yeah, she's just.
But you can tell. Can you just pop a piece of paper to me or to my junior, just so that I'd just quite like to know.
Can you?
Yeah. You handing these up, or we just?
I will do. Yeah.
Was it like that yesterday?
I don't know. I didn't notice.
Yeah, wasn't it?
I don't know.
Yeah. Just refreshing on YouTube just to check. Yes, it's blank here, but it's on that stage. Oh, great, no problem. Okay, thank you.
Really?
It's live here. All right. Still heard in the matter of James-Barclay-Watt and others, and Alpha Panareti Public Limited and others.
Yes, Mr. Parker.
May it please your lordship, I need to correct one answer that I gave to your lordships and your ladyship yesterday about the question of commissions. I said there was no direct evidence of any commissions having been revealed to the claimants. In fact, there is evidence of one such revelation, and I'm grateful to my instructing solicitor for pointing it out to me. And really, it's just for your lordships and ladyships to note. It's paragraph 12 of Mr. Rainford's witness statement, which is at page 82 of the supplemental bundle. He says this. Towards the last week of March 2007, I decided this must be okay if it's selling this fast, so I was persuaded to pay reservation deposits of X for legal fees. I was told I would get back £1,000 for each property, which was part of his commission. That's the agent, Mr. Eccles. A sign of goodwill, he said. And he also referred to the same in his oral evidence, and again, for your lordships and ladyships, note in the electronic bundle of transcripts. It's at electronic page 278, printed page 276, internal page 166, lines 19 to 24, where he referred to it again. But it's only right that I should tell your lordships and ladyship that in the light of the answer that I mistakenly gave to you yesterday. I'm also grateful, my lord, to bringing my attention to the Wood case that you mentioned.
Oh yes, is there anything in that?
There isn't anything that I think that it would be sensible for me to elaborate on, although I understand that my learned friend has a comment that he wishes to make on it. Perhaps I might need to comment on his comment, but I don't know what his comment is yet.
Yes. Right. Thank you very much. Well, Mr. Nathan, we don't need to hear from you on the appeal. We do want to hear from you on the cross appeal. In fact, we regard the cross appeal as giving rise to some quite difficult points. So we would welcome the opportunity that the timing gives us to look at some of the cases properly in order to understand how they all fit together.
So, my Lord, I won't address you further then on my learned friends appeal, and I'll pass straight away to the to our cross appeal. If your Lordship will give me a moment.
Yes.
If I can find where I found this. Now, my Lord, as I see the position, the learned judge, in his judgment in the on the matters of the cross appeal claim against the second defendant, was incredibly brief. His judgment in relation to that is just over 1 page in a judgment which goes on for 37 pages. It's 50 lines, in which he deals with or purports to deal with 2 alternative claims. A claim in relation, on the footing of an assumption of personal responsibility along the lines of Hedley, Byrne and Heller. And secondly, the alternative, that the second defendant had attracted a joint liability or an accessory liability by virtue of the participation the part that he played in the relevant acts concerning the tort which the judge has found. Now, our fundamental criticism is that the judge has, in fact, in his judgment, has run the two almost inextricably together without keeping them apart. And what I need, I think, probably to take your Lordships to first is so that we can just look at what the learned judge said. In my written skeleton, we have set out a number of criticisms, but if I may just try to develop those swiftly, orally.
So you want to look at the judgment first? Is that what you said?
So if we could look at the judgment. And it starts...
Paragraph 58.
Got myself in a muddle. It starts at page 79 of tab 5, at paragraph 58. This is put by the claimants in 2 ways. First, he said, and may I emphasize that our appeal is in relation to the second limb only. We do not pursue a claim on the footing that the second defendant assumed a personal responsibility a la Hedley, Byrne and Heller. It is confined, and as we've made clear in our skeleton argument, I hope, it is confined to the accessory liability issue. And it's important because, however, we may need to dip into and look at what the judge said on both, because, as I say, I think he has managed to confuse things and tried to run them together in such a way that it's quite difficult to discern what he's saying about one and what he's saying about the other. Conventionally, I don't say any judge has to do it in a conventional way. What one would expect is that each limb of that claim would then be set out. He would deal first with assumption of responsibility. He'd set out the legal principles which apply. He'd set out the material that was being relied on, and then reach his conclusion as to whether or not that was satisfied. And then go on to deal with the question of whether or not the exception would apply based upon Williams and natural life, where you would look to see whether or not the director had crossed the line and gone beyond that which would be his normal activity, such as he had therefore must be taken in law to have assumed a responsibility. This is not necessarily a factual exercise, it's actually a legal exercise that one does. Now, that's how I would have expected, or one would conventionally have expected a judge to address that. Now, in relation to accessory liability, one would expect him then separately to have gone through the same exercise, identifying the particular principles which apply to accessory liability, then probably repeating in large measure what he has said in terms of the facts, and then gone on to identify what is the material which, but for the fact that the defendant is a director, would attract liability. And then to go on to explain or to consider why it is that this particular director should be exempt from liability by virtue of the principles set out by Lord Justice Chadwick in MCA and Charlie Records. He did none of those things. And the result is, I expect to say that we've got a judgment which is sufficiently unclear to say that really, to this court, that one should start again. Paragraph 58. This is put by the claimants in two ways. First, he is said to have owed a personal duty to the claimants, and secondly, he was a joint tortfeasor. As to the latter, I consider this can only amount to a case where he was a joint tortfeasor with the first defendant, APP, and I don't think we ever set out to say anything else. As I have not been tasked to find and do not find that the agents and sub-agents, such as Messrs. Pollard, Shaw, and Heath, Miss Welsby, and all the others, were liable in negligence to the claimants. But even then, I would need to be satisfied that he was a joint feasor personally, as opposed to APP, so the question is the same. Now, I don't know what he means by the question is the same. It doesn't, it's completely...
Well, isn't he saying, Mr. Nathan, that there has to be some legal principle upon which, despite the fact that he is a director and his company may be liable in tort, he also attracts a liability?
Yes.
So irrespective of who he is accessory to, it's the same question, which is there something which attracts a personal liability?
What foxes me, if I might say, is this. But even then, I would still need to be satisfied that he was a joint tortfeasor personally. I don't have a problem with that. As opposed to APP, so the question is the same. Because the nature of accessory liability, and he is clearly talking here about accessory liability, is step one is to find that there is an act of, in this case, breach of a duty of care on the part of the company.
Yes.
He's so found before. The next step then is to consider the conduct of the individual in order to see whether he has taken steps which fulfill the conditions which are set out very clearly in the Sea Shepherd case in the Supreme Court. But what is therefore difficult to understand is when he says a joint tortfeasor personally as opposed to APP. So it may be all that he is saying. It's a little obscure, but maybe all that he is saying is that whether it's the agents or whether it's the company, I'm still doing the same exercise. And if that's,
I think that's what he's saying.
If that's so, then it's a very small criticism, but it's certainly quite difficult. But it leads one into a concern. Then
I read his even then as saying, well, if I were doing the exercise, which I am not doing, and I've just said that I'm not doing, then I still need to be satisfied that he's a joint tortfeasor himself.
He's a joint tortfeasor himself by virtue of the acts which are accessory to the acts of. It wouldn't necessarily be the same. It would not necessarily be the same exercise if he's looking at the company as opposed to the individual agents. It's not necessarily the same exercise.
Right.
Anyway, there we are. Then the next step is he sets out 6 different facts which he considers to be the relevant ones. He said because he was a Svengali, and he had earlier founders, my lords will recall, that he said that he rejected the sobriquet Svengali, but he indicated that he was close to it, not entirely. Because the marketing scheme was his master plan or brainchild, and he was its hub. Third fact, that he micromanaged at least a UVR, if not BROPUC, and he approved the contents of the brochures and DVDs, and that he'd been the only witness for the defendants, and no other witnesses have been called, although others have featured on behalf of APP, not just Mrs. Nurse, which and then it was not put to him that APP is or was a one-man company, and indeed, in the light of at least those individuals, it would seem plainly it wasn't. So it's hardly surprising it wasn't suggested, although that of itself would not be enough. And then no board minutes or articles of association were produced, although I don't know if discovery of them was sought. Now,
You broke that down into 6 facts.
Six.
Was that a fair summary of your case on personal liability?
We went in much greater detail. As my lords will see from, we've got our closing submissions, which go on for many paragraphs, setting out. But if one uses an umbrella phrase, he masterminded and controlled everything. He controlled the entire, or was, sorry, not controlled, he was a party by his control and his actions to the training, which we don't have any mention here at all, which is a critically important part of what the agents were doing. He was a party to the provision of information to the customers, to the investors. Obviously, the most important part was the DVDs and the brochures. He was also party to the reservation information which was provided to the clients, an example of which we find in the case of Mr. Bright. And perhaps we might just swiftly look at that, because it's quite a useful document. We find that in Supplemental Bundle, Volume 1. I apologize. It's in volume. Yes, it's volume 1, tab 31, page 319. I'll develop in a moment a little bit more about how the agents, what the system was. Well, perhaps I can develop it now. The way matters worked is that the agent would come forward, would come to the person's home. If he had been an advisor before, he managed to get his foot through the door and his bottom onto the sofa by virtue of the fact that he had that existing relationship before he set about his hard sell, as the judge called it. And the agent would produce, as we heard in the trial, the agent would produce a laptop, go through all sorts of material, provide the DVD, provide the brochure, and the objective was to persuade the client to enter into a reservation contract, we say, with Alpha Panareti, which then produced this document. And that's before the contract is ever entered into with Alpha Panareti. So we say that there's in fact a two-stage contractual process. A reservation contract, £2,000 deposit paid, specific terms laid down for the reservation, the only person who was conducting that contract on behalf of AP at any stage at all, so far as the client is concerned, is the agent who gave the information, obtained the reservation, collected the money, whether it's in the form of a credit card slip or alternatively in the form of a check. If it was a check, he passed it up to ROPUC, which then banked the check. But the only individual that the clients ever saw at all or dealt with at all at that stage was the agent. And the information which is contained in the reservation document reflects what the agent was been saying in the oral part of his presentation, hard sell. And starting at 319, one sees at the bottom of the page the total price. In this case, for the Brights, was 179,000 odd Cypriot pounds, close on 200,000 pounds sterling. In fact, we see, if we go to page 323, we now see at the bottom of the page, the sterling price is 218,000, a deposit of 15,000, 15%, and then 5% being paid at the end. Then the Alpha Bank loan, again in Cypriot pounds. Bear in mind that, of course, it was in Swiss francs. The loan amount was 143 Cypriot pounds, producing at a rate of interest, 2.95% in this case, 711 pounds, Cypriot pounds per month. And the mortgage loan process, as one observes in this document, contains some information about Alpha Bank. But what one notices immediately is that there is no, and we look through this reservation document, there is no page headed risks. Conventionally, one would expect in some kind of advisory investment document, an investment document, a page which says what the risks are. And we know that there are at least two lots of risks in this case. There's the currency exchange risk and also the risk that the bank may change its terms. Its own profit margin by increasing its 1.75% take on top of Swiss franc LIBOR. Then one goes over the page to what was, you see on page 324 that certain additional charges are added, which are then going to be rolled up into the mortgage loan facility. And then on the next page, 325, all important, because these investments, as the judge said, it was explained to all of the investors that these were supposed to wash their face. And here we see the estimated rental forecast, and towards the middle of the page, annual rental income after all charges, £7,456, and I'm assuming that that's in Cypriot pounds, but it's like that here. And that produces £621 monthly, which is slightly short of the £711, which is necessary to pay the monthly bank loan, but it's based upon only, as you see at the top of the page, 6 weeks, 10 weeks, and 10 weeks, low season, 10 weeks of mid-season, 10 weeks of high season, based on 26 weeks of the year. You only had to achieve 6 more weeks in order to be able to break even. And then one sees on page 327, so there's no doubt about it, this unit reservation form has been generated on behalf of Alpha Panareti to confirm the purchase of Iris B2 on St George Hills today. Then the reservation deposit and so on will secure. that's entirely consistent with what was being the information provided to the customer. And again, here on this page, one doesn't see anything at all about any warning about any kind of risks in this document. But one recording what perhaps has been said to the clients. And it is, I think, common ground that none of the salesmen ever warned anybody about anything at all about risks. All that they did was sing the praises of the Alpha Panareti mortgage scheme.
Well, I see how this helps you on Alpha Panareti, but how does it help you on Mr.
Well, it comes because it comes in twice over. Not only Alpha Panareti, but then one needs to look and see what is the responsibility and the participation of Mr. Joannou as his act or his omission, which is the first step of the Sea Shepherd chain of conditions that one needs to look at. Now, if I go back to the judgment, what is unclear from paragraph 59 is which of these facts goes to which particular causes of action. The fact, for example, at the bottom of the page that no board minutes or articles of association were produced is directly relevant to the position in relation to accessory liability. It has nothing whatever to do with him personally assuming responsibility. Then it was not put to him that APP is or was a one-man company, and so on, although that of itself would not be enough. Again, that seems... These are all material that are being put forward in relation to both. It would seem, on the face of it, looking at the authorities, can only be confined to the question of the assumption of responsibility, because one is looking at the acts for the purposes of Sea Shepherd, and not whether or not the company is a one-man band or anything else. It doesn't matter for the purposes of accessory liability. Then we go to paragraph 60. The question is whether he has become liable as well as the company of which he is managing director. Now, that in itself is an important question because he has decided that he's managing director. The learned judge had no documents of any kind from the company in relation to its constitution, no board minutes, no articles of association, no records of meetings of the company giving any kind of authority to Mr. Joannou. All that we have is that he Mr. Joannou, self-styled himself managing director. And I say self-styled because his evidence on day 26, the Lordships will give me one moment. Sorry, it's day 20 at page 117. We have the extracts on
He seems to have been cross-examined for a long time.
It's one starts at 118, I'm sorry. Page 980 at the bottom, which is the main transcript.
I'm sorry, looking at the transcript extracts bundle.
Yes.
On which page in that?
The extracts bundle is tabbed according to the days.
Yes.
So 20 is day
I see.
20.
Go to page 20.
Page 980.
Thank you.
And one really needs to pick it up at the bottom of page 117. When did you start taking over the management of it, the company, and build up your own relationship with the bank? Just to make it clear, mate, because maybe I wasn't correct earlier, I've already mentioned that I am director, and the second director is my father. This means I am not managing. It doesn't have such a thing in Cyprus. If you own jointly and somebody else, means that the decision is equal, or you have a power of attorney to represent. So just to make sure that we are not, I look arrogant, I'm not suggesting for a moment that you're looking arrogant. I'm trying to understand the structure of your company. Therefore, because we see a lot of business decisions being made by you, contracts signed by you, and without your father's signature, so it obviously follows that you must have some power to commit your company to various things. No, this is incorrect, Mr. Nathan. If you look at the contracts, all the contracts are signed by myself, but under my signature it says, under the power of attorney, it has a number. So you hold a power of attorney to be able to commit the company to business commitments of one kind or another. That's all I'm asking you. That is the correct description. And then the judge, can you give us some idea as to when your father, who remains a director, switched off, in the sense that he left you in charge, with him giving you a power of attorney and generally being there to give advice? When did you become the driving force of the company? There is up to now, my lord, I am not a driving force, well, the judge found against him. I have equal rights as the other directors, and for the purpose of those contracts which we needed to be signed, and it was a business where he is not, I don't know in English, he cannot read English. It would be very difficult to translate and make it. So after all, he has given me the power of attorney to represent his part for that purpose. So other than that, the operation, how to build, and in general, he has equal responsibility and equal say to this. I was never jumping in the way of taking all the decisions, and then he was behind. I'm sorry, I don't understand that he was behind. What do you mean by that? I mean by that I was never taking any decision which he was not informed or he was not involved in way he knew what was going to be done. And then he's skipping one question. No, but there must be a time when your father was doing most of the business and you were helping him. When that changed to when you were doing most of the business. And he, of course, knew everything that was going on and you consulted him. But he wasn't any longer running the business. Roughly when did that happen? That's what we want to know. This is the way you put it, my lord. I would say after 2008. So effectively, insofar as he takes over in any kind of responsible way, it's 2008. But important, so far as, and when we come to look at the MCA case, it's important to see, and the very helpful decision last year of the Court of Appeal in Lifestyle, it's very important to see what actually is the constitutional role, the role that he's playing in accordance with the Constitution.
Did you not ask for disclosure of the constitutional document?
There was nothing was disclosed.
Sorry?
Sorry, nothing at all was disclosed. We had nothing. No, we never saw any powers of attorney at all. This was the only material on which the judge had to work, on the basis as the constitutional.
Did you not ask for disclosure?
I'm sorry, Lord.
Did you not ask for disclosure?
We did not ask specifically for disclosure.
And they're not publicly available?
Not publicly available. It's one of the difficulties in Cyprus of actually getting disclosure of company records. It's just like the land registry, you can't. It's not open publicly. The important point, I'll make it again later on in a moment, but the case of Lifestyle makes absolutely clear in paragraphs 48 and 49 that is no part of our obligation to make a case to say that he has no authority. The evidential burden lies entirely upon the person who wishes to assert that he has an exemption by virtue of his actions being within his constitutional role, such as voting at a board meeting. And as the Court of Appeal in Lifestyle emphasises, it becomes all the more important where somebody is relying upon some kind of delegated authority. Because if he hasn't got that authority, then he's out and he's liable. And he cannot turn around and say, oh, but I could have done it properly, but I didn't do it, then he's still liable. So it's the combination of MCA records and MCA and Charlie records on the one hand, and the Court of Appeal last year in Lifestyle emphasising what it is that the defendant has got to establish, and in this case has not established.
Well, at the moment, it seems to me that the defendant's evidence is, I was jointly authorised to run this company with my father.
Mm-hmm.
My father basically was responsible for running the company for a period. After 2008, I did the day-to-day running of the business, but I did so under a power of attorney which he signed, and I kept him informed.
Yeah, but he's saying that I kept him informed.
Yes.
However, what we've not seen is any power of attorney. It's no use. It's not enough simply to say I did this under power of attorney, without actually showing what the power of attorney actually says. Because we see that, for example, he says when you look at the contracts which I signed on behalf of the company, the sale contracts, you'll see that everyone has always got a reference to the power of attorney with a number.
Yes.
So that's a power of attorney to sign contracts. That's the only one which he has in fact identified as actually existing.
But I'm just trying to, at the moment, work out where this is going in terms of his acts. Are you saying that if he doesn't have a specific power of attorney to provide information, for example, on behalf of the company, even though he's a co-director with his father, and therefore you would expect him to have certain powers to act on behalf of the company by virtue of being a company director, that somehow takes him outside of acting qua director and makes him liable for an act outside of his role as director, thereby giving him an accessory liability. Is that the way this is going?
Can I put it in this way? One looks at the acts which the person has done.
Yes.
One then looks to see what is his constitutional role. He is a director.
Yes.
Both MCA records and Lifestyle indicate that the narrow exception that exists for the and the word I think is used by Lord Justice Chadwick is one which you have to get yourself into the box of constitutional role. If he'd simply taken decisions in the board, that would exempt him. If he becomes in effect a senior manager of the company, then you look to see what it is what are the specific powers that have been delegated to him by the board, if any at all. And he is quite emphatic that there is no such thing as a general managing director. It's got to be something specific, says he. And therefore there is nothing which is provided. May I just take it out of turn, but to look at the Lifestyle case, which...
Well, I don't want to take you out of
no, well, I'm quite
your
happy
way.
to do so.
I'm just trying to feel my way to
Yes.
what the end submission is, Mr. Nathan, before we actually get into the nitty-gritty of the law.
Yeah.
But as I understand it, what you're saying is that insofar as he has done any act which purports to be in the name of the company or on behalf of the company, he can't escape an accessory liability as a joint tortfeasor simply by virtue of his agency status, he has to show that in respect of that act there is a specific authorisation.
Yes.
That's
He has-
really the
he
point
has-
you're
he has-
making.
He has to show that the power that he was exercising to act in this way is one which is formally delegated.
Formally delegated.
Formally
to.
delegated.
That's all I wanted
Yes,
to
no,
know.
well, it's
all
all-
I wanted to know
yes.
was where this was going. So
Yes,
that's very
it requires a formal act of delegation.
all right.
So any senior manager who is not a director, but who is nevertheless running the company, is likely to be personally liable as an accessory for the company's torts. Is that the consequence of your submission?
It's the consequence of my submission, but the submission comes from, in fact, the position which is adopted in MCA and Charlie by Lord Justice Chadwick in his first and second principles. That and therein lies the problem, because what essentially the court was seeking to do was to balance the competing public interests. On the one hand, that those who are responsible for directing a company and the way the company operates should, just in the same way that shareholders ought not to be liable in certain ways. So that, for example, a shareholder who votes in a general meeting is not personally liable under the MCA and Charlie principle. So too, the director who votes in a board meeting, by that action, he is not engaging personal responsibility. But when he becomes acts in a senior management role, he is, unless he can show that he has a formal delegated authority constitutionally.
Yes. Well, I think one thing it may be relevant to think about when we come to look at the cases, and like my lady, I don't want
Yes.
you to go out of your course, is whether there is a difference in applying these principles according to the nature of the tort. So, for example, you've got cases which are concerned with ramming a ship. You've got cases about infringement of intellectual property rights. And you've got cases about liability for misrepresentations.
Yes.
Now, one thing which interested me from an initial reading of them is whether different considerations may apply depending on the nature of the tort.
There are certain kinds of torts which may engage with strict liability on the part of the person who commits the tort. But I say that there is no difference whatsoever so far as responsibility is concerned. The way in which it is dealt with, as Lord Neuberger, we've used Lord Neuberger's judgment for present purposes because he encapsulates what we think is entirely typical of all the rest of their lordships. But we can look at what each of them say in the Supreme Court. But the touchstone is that if there is a liability, it must be, you only get a liability, you find yourself liable, so long as the act that you've engaged in is not trivial or de minimis. It may be small, perfectly well be small. I think it's paragraph 50 of the judgment. I'll stand corrected in a second. The way that the law deals with it is by allocating responsibility as between the tortfeasors. So that if, in fact, it's something for which the company should bear 90% or 95% responsibility, then that is how it is allocated as between the two tortfeasors. But that's not something that the claimant is concerned with at all. And in fact, it reflects, I think, properly the way in which real life works, where directors and senior managers are all insured by their company as individuals, as well as the company insuring itself. Perfectly normal thing these days for individual managers, senior managers.
Yes, but that would normally be your classic example of vicarious liability, which is not what we're talking about at all here.
No. Well, yeah, but you may. It's simply that if, for example, the director, the senior manager, while he's driving along, there are, you can think of situations where both the company and he may be responsible. For example, because the car is defective, he knows it, the company knows it, they're both liable. And it's not a question of vicarious liability. Then the law will allocate responsibility as between them. But the claimant's not interested, concerned with that.
Yes, but that's not a case where his liability is the company's liability. It's a case where he has his own independent liability for the tort. So he commits the tort, and the company also commits a tort, and they're both liable to the injured party.
I'm sorry, but then perhaps we can put it in the way of he's the person who forgot to put the stopper back on the brake bottle or brake bottle. I mean, the difficulty is, as soon as one starts trying to give examples, one can one of the important elements which is emphasised in Sea Shepherd and in all the other cases is that when it comes to the question of joint tortfeasors, the factual inquiry, it's a fact-intensive case, and you should not be laying down principles or situations too rigidly. You've got to look at each individual case on its own merit.
That I can well appreciate, but of course one has to bear in mind the way in which one comes up with a demarcation line between classic Salomon and Salomon principles and the area that we're now moving in, where there is a personal liability notwithstanding that there is a corporate entity of which the individual is a director.
I think that the matter of public policy and public principle is simply this, that a person should be responsible for liable for his own wrongdoing, his own wrongful acts, regardless of label, is it a corporate act being done on behalf of a company or not?
Yes.
And the difference between that and the Salomon and Salomon situation is that in Salomon, you're of course it's a contractual question there. You're looking at voluntary acts vis-a-vis the company, which the claimant is engaged in, and he's trying to penetrate the corporate veil. This is not a question of penetrating the corporate veil at all, because you start off with
except that corporate veil cases are not confined to cases of contract; they extend to tort cases too.
But that's the difficulty. As soon as one uses penetrating corporate veil.
That's why this is a difficult case.
Yes, and
it is very odd that a director who does everything, or a manager who does everything for the company, is not liable under any primary liability for misrepresentation, because he, as distinct from the company, has not assumed a personal responsibility. But he is nevertheless liable as an accessory on the basis of the very same conduct.
Well, there are two different strands or two different routes to liability. Our argument, I have to say, my Lord, I think we've made it fairly clear in our skeleton argument, is we say that this exception shouldn't exist, and if were we to go to the Supreme Court over this matter, we would be arguing that MCA and Charlie is in fact not right. There isn't any exemption in the case of a director, because but that's a different.
Williams was wrongly decided.
Yeah, but that's. I mean, I can't say that in this court. I don't propose to do so. I'm going to loyally follow it, but subject to that caveat. But I'm arguing on the footing that MCA and Charlie are correctly decided. I'm arguing that lifestyle has been correctly decided. I think maybe what would be most helpful is if we go directly to MCA and look at what Lord Justice Chadwick said, because it's actually so important. And my lords and my lady will find it at tab 37. I have it in my volume 3. And may I say, we've cited in our skeleton argument a number of cases where it is well accepted that a director can be personally liable on the basis of accessory liability. Cases such as the Königlicher Phillips case and so on. It's a well accepted route to liability. And in those cases where the director has been found liable, sometimes in the case of a one-man band, sometimes in the case not, the director has engaged in actions which are ones of procuring, aiding, assisting, or whatever the company in the commission of a tort. Now, if I begin with, Lord Justice Chadwick sets out and recites a considerable body of authority. I don't think that I need to read to your lordships all the cases which he relies on in order to arrive at what is a well-known series of propositions, which is at paragraph 49. Or perhaps start at paragraph 48, because this is his beginning of his summary. It is because there is a balance to be struck on the facts of each case that it is dangerous for an appellate court to appear to attempt a formulation of the principles which may come to be regarded as prescriptive. But I think it can be said with some confidence that the following propositions are supported by the authorities to which I have referred. First, a director will not be treated as liable with a company as a joint tortfeasor if he does no more than carry out his constitutional role in the governance of the company. That is to say, by voting at board meetings. That, I think, is what policy requires if a proper recognition is to be given to the identity of the company as a separate legal person. Nor, it seems to me, will it be right to hold a controlling shareholder liable as a joint tortfeasor if he does no more than exercise his powers of control through the constitutional organs of the company, for example, by voting at general meetings and by exercising the powers to appoint directors. Lord Justice Alders suggested in Standard Chartered Bank and Pakistan National Shipping Corporation, in a passage to which I have referred, that there are good reasons to conclude that the carrying out of the duties of a director would never be sufficient to make a director liable. So if he's sitting in the boardroom, he's home and free. For my part, I would hesitate to use the word never in this field, but I would accept that if all a director is doing is carrying out the duties entrusted to him as such by the company, under its constitution, the circumstances in which it would be right to hold him liable as a joint tortfeasor of the company would be rare indeed. That is not to say, of course, that he might not be liable for his own separate tort, as Lord Justice Alders recognised in paragraphs 16 and 17 in his judgment in the Pakistan National Shipping case. Second, there is no reason why a company who happens to be a director or controlling shareholder of the company should not be liable with the company as a joint tortfeasor if he is not exercising control through the constitutional organs of the company, and the circumstances are such that he would be so liable if he were not a director or controlling shareholder, a position that I've been positing to my Lord and my Lady. In other words, if in relation to the wrongful acts which are the subject of complaint, the liability of the individual as a joint tortfeasor with a company arises from his participation or involvement in ways which go beyond the exercise of constitutional control. In other words, he's acting as a manager in a management role, then there's no reason why the individual should escape liability because it could have procured those same acts through the exercise of constitutional control. As I've said, it seems to me that this is the point made by Mr. Justice Alders, as he then was, in PGL Research and Ardent International Limited. And then third, the question whether the individual is liable with the company as a joint tortfeasor, at least in the field of intellectual property, is to be determined under principles identified in CBS Songs of Amstrad Consumer and Unilever PLC and Gillette. In particular, liability as a joint tortfeasor may arise where, in the words of Lord Templeman, in the CBS Songs and Amstrad case, to which I have already referred, the individual intends and procures and shares a common design that the infringement shall take place.
Yes, he was partly with paragraph 51 in mind that I asked the question
Yes,
whether the
well,
position may be different
and-
in
and
relation
I
to...
think-
diff-
I
just
think-
a
I
moment,
think that
just a
that-
moment, just a moment.
Intellectual.
Sorry, be quiet, Mr. Nathan. I'm trying to say
I'm sorry.
something. It was partly because of paragraph 51 that I asked the question whether the position may be different in relation to different torts, because it talks about, at least in the field of intellectual property, and in part because looking back at paragraph 43, Lord Justice Chadwick seems to give a different rationale in the case of torts which depend upon an assumption of responsibility, where he is
Yes.
discussing Williams.
Yes.
All right,
Yes.
I've finished now, and you can reply.
I think the most important thing, which is one needs probably to do, is always to bear in mind that the case of Williams is in a sense, it's slightly oddball, because it was a case which is confined to Hedleyburn and Heller. There was an attempt to bring in the House of Lords an argument about joint liability, and it was not permitted. A, because it wasn't pleaded, and B, because that argument had been expressly abandoned in the Court of Appeal, and therefore the Williams and Natural Life Health Foods is a case which is limited specifically to a Hedleyburn and Heller assumption of risk.
Well, you're right, of course, that the primary reason for saying what was said was that the point was not open in the House of Lords for the reasons that you've given. But Lord Steyne went on to deal with it on the merits in the passage quoted at paragraph 42 of MCA, and Lord Justice Chadwick doesn't say that that is wrong. He gives a rationale for it, which is
yes.
not saying a director can never be liable, but saying the basis of it is that Mr. Mislin, the director, couldn't be liable in that case because he was not party to the special relationship giving rise to the assumption of responsibility.
Precisely. So if one is looking to the Hedleyburn and Heller depends upon the creation of a special relationship, an assumption of responsibility giving rise, which is the product of that special relationship. It doesn't have to be. One uses these phrases, special relationship, and there's a legal labels given to the particular factual circumstances which give rise to the law identifying that person as having assumed a personal responsibility. But it's important to distinguish these two lines or routes of liability, because if you confuse them, I would respectfully say you begin to get lost, because the principles which are to be applied are very, very different. And that is why it has become so important to be able to refer, as we are now able to do, and as Sir Michael Burton was able to do, to refer to C. Shepherd, which sets out the principles for accessory liability or joint liability. And it is a clear attempt by the Supreme Court to set out general principles which apply, taken from the cases going back to the 19th century, including cases like the Kursk and so on. And the Supreme Court is all of the same view as to what are the requisite elements of accessory liability. I think the only slight difference that I can discern is that Lord Neuberger refers to the act which the person carries out, which is tortious, and the Lord Sumption refers to it as being an act which may turn out to be tortious. In other words, you don't, at the time when you are doing whatever you're doing, you don't necessarily need to know that it's tortious. You are just looking at act, common design, and so forth. And it's very helpful. Can I, going from here, go on to the lifestyle case, which is on back.
Tab 35.
35, yes.
Yes.
And if you give me one moment. Because I think that for present purposes, my lords and my lady really probably now only need to refer to this authority because it summarises where we are at the moment. First of all, if we go to paragraph 31, well, maybe we just, in a sense, I'm going back to front, but I'm assuming that I'm going to be able to satisfy, for this part of the argument, that I'm going to be able to satisfy the court that there is a relevant act and that there is common design and so forth. So, picking up at paragraph 30, in the present case, the facts of the Ahmed's conduct was clearly deliberate and intentional in the sense I've described already, means that they've satisfied the test in fish and sea shepherd. The only basis upon which this ground of appeal can succeed is the footing that they were directors of the company. In fairness, that is how counsel put the case on their behalf, but it bears emphasising at this stage. This means that the 2 points identified above, state of mind and director's duties, in effect come to the same issue. Turning to MCA and Charlie, Lord Justice Chadwick noted in paragraph 47 that in Mentmore, the question of whether and in what circumstances a director should be liable to the company was described as a difficult question of policy, and that in the end, a balance had to be struck between two considerations. The first consideration is the distinction between a company as a distinct legal person and its shareholders, directors, and officers, the point my lady has drawn attention to. And the second is that everyone should be answerable for their tortious acts. The judge then made the point that because there was a balance to be struck in each case, it was dangerous for an appellate court to attempt a formulation of the principles, and since it may come to be regarded as prescriptive. Nevertheless, Lord Justice Chadwick did feel able to formulate the 4 principles which he then set out. And then, given their centrality, he then Lord Justice Best sets out those principles. And then the important principles for paragraph 33, the important principles of the first 2, but before turning to them, I note the careful statement by Lord Justice Chadwick in paragraph 51, that he was stating that the principle there, at least in the field of intellectual property. As I've said above on Lifestyle's appeal, I can see no reason why the principles applicable should differ as between these cases and others. Nevertheless, which I think answers my Lord's point, nevertheless, every judicial statement of the law has to be understood in the context and circumstances in which it is made. Like Lord Justice Chadwick, I am seeking to identify the applicable principles in the context of this case, which is about infringement of intellectual property rights. Lord Justice Chadwick's paragraphs 49 and 50 fit together. In my judgment, they substantially answer the issue in this appeal. They explain that the grounds on which a company director may be found to be an accessory are not wider than those applicable to other people. So to be found liable, one way of approaching the matter will be to ask whether the individual's conduct would make them liable as an accessory in any event, irrespective of their status as a director. Assuming that that is so, then the next question is whether the fact that the person is a director of the company means they have a defence open to them. They may do so, but only if the conduct which has made them potentially liable amounts to their doing no more than carrying out their constitutional role in the governance of the company. Now, one sees, therefore, how narrow the exception is, and it's in the form of a defence. It's not something that we need to disprove. The defendant needs to prove it. And that is and that's repeated again in the course of paragraph 40. Maybe it should be paragraph 36 is perhaps helpful. Furthermore, the converse is also true. If the individual's conduct doesn't make them liable as an accessory, then the fact that they are a director in and of itself cannot make them liable when they would not be otherwise. That was also made clear by Lord Justice Chadwick in paragraph 37 of the same judgment, in which he held it was a correct statement of the law that a director or other officer of a company may in certain circumstances be personally liable for the company's torts, although they will not be liable merely because they are an officer. They must be personally involved in the commission of the tort to an extent sufficient to render them liable as a joint tortfeasor. Whether they are sufficiently involved is a question of fact requiring examination of the particular role played by them in the commission of the tort. I don't read Lord Justice Chadwick's paragraph 49 or any other part of his judgment as being so prescriptive as to mean that the only thing which amounts to carrying out the director's constitutional role as voting at board meetings, but it is clear that Lord Justice Chadwick had in mind a narrow exception. That's where I got the phrase from. It is not surprising, given his recognition that a balance is involved and everyone should be liable for their tortious act. So the starting point is everybody should be liable. But as a matter of public policy, one balances that against a narrow exception in favour of directors doing something within their constitutional role and not otherwise. And essentially, a management role is not a constitutional role, but it may be that some powers of the board of directors have been delegated, but if so, you've got to prove it. As Lord Justice Burr says in a moment.
In what sense has Mr. Ioannou committed a tortious act for which he should be held responsible when, ex hypothesi, he has no liability as a primary tortfeasor?
He's not the primary tortfeasor. The company is the primary tortfeasor. However, because of the way, in fact, as we know that from the judgment, he conducted himself. First of all, he's the driving force of the company. We set out in paragraph 25 of our skeleton the facets which we say.
Well, I get all that, but
well,
you accept
the next important part is
of being a primary tortfeasor.
I'm sorry, Lord.
I said I get all that he's the driving force and so on. But you accept that you cannot sue him as having liability as a primary tortfeasor.
Yes.
He's only liable
for his accessory for his accessory actions. Yes, and those actions are effectively what did he procure and drive the company to do?
Yes,
as the
you've got to show an act of procurement, haven't you?
Well, it's not necessarily an act of procurement. It's an act of involvement in the tort. So
well, your pleading case is that he directed or procured.
He directed or procured, and what he did not direct and procure or omitted was to that a warning, a general warning, any kind of warning, should be given by the company to the investors of the risks, and the one which the judge addresses in particular is what he says is the obvious risk. And if it's obvious to the company, to Mr. Ioannou, it must be equally obvious.
So does it boil down to this, Mr. Nathan, that your case is that Mr. Ioannou directed or procured that the company should issue literature or sales literature as part of its promotional efforts for this scheme, which did not warn of an obvious risk.
Yes, precisely.
And you say he didn't just direct it, you say that he actually drafted it.
Well, no, I don't need to go that far because he's so.
I thought you did say that.
Sorry?
I thought you do say
Well,
that.
no, I mean he was clearly involved as the manager who was directing, as the driving force. He was directing everything that was being said on behalf of the company to the public, starting with the starting with a website, where the heralding of the Alpha Panareti mortgage scheme. All of these things he's closely involved in doing. And it doesn't matter that, I use the word closely, I don't even need the word closely, he just needs involved. Equally, he's involved in the production of what it is that is being told to the public. And that's why his role in the training sessions becomes very important. And why it is explained by one of the witnesses that these were large open sessions with a number of different people participating, including Mr. Joannou. And he actively participated in relation, for example, to what the bank was saying. He'd actually it wasn't just the bank giving. I've been telling you, Lord, to my lady, that if I'd been required to deal with the question of my learned friend's appeal. However, the fact is that Mr. Joannou was, if I can put it this way, was right in there up to his armpits in directing what it was that the company should be saying. To the extent that, for example, there's a letter which is written to Mr. Rainford about one of the agents, Mr. Eccles. And Mr. Joannou carefully emphasizes that Mr. Eccles was being carefully trained and he'd gone off the rails. This is something which clearly Mr. Joannou was carefully controlling as to what was being said or not being said. And understandably so. I'm not making it as a complaint. I readily understand why he would be doing that, because it was his company, where they were going, and his company was making hundreds of millions of euros out of this. I mean, one of the documents, I think it's in the file, but certainly we had it before the trial, that Ropuck alone sold 260 million euros worth of apartments and villas. It was a very big business, which Mr. Joannou, with a very small management team, consisting effectively of himself and Mrs. Nurse, was running.
If the director procured to protect himself, that each act, for instance, the issue of the DVD or any brochures or whatever, or any other training was authorised by board resolution.
There's no one. Sorry,
Can I ask my question for you?
I'm sorry.
Before you answer it. If he was to procure that if he was arranged that each procurement of those things happening was authorised by board resolution, he couldn't be liable, as I understand it, for his act in so voting.
Exactly.
But could he be liable for the other acts he did in, for example, drafting the literature, or does the obtaining the resolution? Shall I ask the question, then you answer it? Yeah. Does the obtaining the resolution, sort of as it were, remove all sins?
I think it's difficult to answer positively one way or another, because one has got to look at the specific action. But I think if it were, taking my Lord's example of drafting the brochure, it's submitted to the board approves it, then it would seem to me that the act of drafting is overtaken by the approval, because it is the document which is actually sent out to the public.
But then if you're in a one-man or two-man company, then you've got all the principles come into play about what directors do actually need to call board meetings. They can authorise things themselves without a board meeting.
Well,
or they can authorise them retrospectively. Well, why can't Mr. Joannou now call a board meeting and authorise all of this?
See, my Lord is now touching upon my concern, which is I don't see how this very narrow, it works this particular case, but I don't see how the principles which have been enunciated by Lord Justice Chadwick really work. Because, as your Lordship says, well, in the case of a one-man band, then he's more likely than to be held liable, in effect, than if it were to be a large corporation where they have formal board meetings and that kind of thing. But
Is he? Because if he's a one-man band, then everything he's doing is, by definition, authorised by the board, as though they passed a
yes,
resolution.
well, and then that in itself becomes quite a difficult thing, because it may be that the law doesn't intend that in such circumstances he should be able to escape through that narrow.
But forgive me, where I think that as he sees the potential difficulty in your argument is if you accept that if a formal resolution had been passed, that would expunge personal liability. I then do have some difficulty in how the actions of a sole director could create personal liability, where everything he does is effectively authorised by the sole director in the way that we know sole directors can act informally. So I'm not sure, and it seems to me a distinction without a difference.
But perhaps you, looking at the time, perhaps you'd like to think about that. It
Yes.
also occurs to me that we have diverted you to some extent, because you started by taking us to the judgment.
Yes, of course.
But we started asking questions and you didn't complete that, and the judge does, after all, make what seems to be a finding that what Mr. Yano didn't go beyond his constitutional control. Then you started telling us about the facts, and I'm not sure you completed that before.
Yes, my lord, I'm afraid.
So perhaps it would be a good idea to take a 5-minute break now, which we're going to do anyway, and enable you to take stock. Maybe you've said most of what you need to say under one form or another, but let's reassert some structure.
Actually, tell me what your points are.
Yes. Just my help. Please, in my judgment, the representatives is a protected area. It's not strict liability making laws, but it's narrow protection of the responsibility. Need seeking to avail himself of that principle, need to put that estate is simply the direct effect of property, and not acted in the sense of a breach of a fiduciary is no defence. Now, somewhere there is in this that if they could have done it constitutionally, but they didn't. They still don't. There's no reason. Here we are. I don't see that. I mean, since this isn't a one-man band, I don't see where it would work. But the principle, no one has suggested. Which of the cases? There's one of those one-man band company cases that we've got. We cite in our skeleton. Just need to have a look. Was it Königliche? It's our paragraph 30. Where's he gone? No, it's paragraph, it's in our paragraph 30 of our skeleton. You look in Koenigsegg, I'll look in Druzhba. What's the company you've got there about? No, Druzhba is a large company. Great. Druzhba. Global Crossing. No. Koenigsegg. This certainly, I can't remember which case it is, which is a one-man band. Post.
Not the auto. So what's that? Autocrat.
Hmm?
Tab 38.
What case?
The autocrat.
Autoshore. Have a look. But it's not a question of whether or not they cover it. They could ex post facto. They could ex post facto give him the delegated power, ratify. But well, that's why it's that degree of formality. But the problem being when it's a delegated power. What about autocraft? Have we got it? Is autocraft a one-man band?
All right.
My Lord, I'll attempt to answer the question that was posed to me, and then revert to the form that I was hoping to take your Lord through. And I think it's this, that so far as the one-man band is concerned, again, what needs to be examined are the facts of each particular case. It is conceivable that the director has prospectively given himself or delegated to himself appropriate powers. But otherwise, you need to see what it is that he is doing. And for example, can I just take my lords to the case of, if we go one tab to 34, which is a case of Königlicher Phillips Electronics and Prinsco Digital Disc GmbH and Chin Shu Kuo. Now, when writing your judgments, of course, you will no doubt read it, but what's quite interesting just to see is what happened in that particular case. If we go to paragraph 18, Mr. Kuo was the Geschäftsführer of a very small company, which is effectively the managing director, albeit under German law, the responsible manager. And turning now to the question of Mr. Kuo's activities, I have no doubt that they extended beyond participation in board meetings. He was the business manager of the company. He was responsible for the cultivation of Aventi as a customer. It was his decision to give the indemnity. While he suggested that Miss Huang, who was his assistant, was responsible for the greater part of the dealings with Aventi, she did so, in my judgment, under his control and supervision. Under cross-examination, he accepted that she did so under his instructions, although I must make proper allowance for the fact that this evidence was given through an interpreter. I find his evidence left me with a clear impression in respect, as in all others, that he was in control of the commercial decisions relating to Mr. Dobson and Aventi. And it's that kind of managerial activity which is what one actually looks at in the context of these cases. Similarly, when we go to, I'm not going to take the lordship to it now, but the other cases that we have cited in paragraph 30 of our written skeleton, context druzhba and global crossing, which is, I can put it this way, it's almost a one-man band, but it's slightly peculiar facts. There are certainly cases, and we'll see if we can find them during the course of the luncheon adjournment, otherwise overnight, showing where that one-man band directors have been held personally liable. And is usually in the context of breaching intellectual property rights. But I don't need, for my present purposes, in this case, to look at one-man band companies, because this was not a one-man band.
Well, there was, what was the shareholding
Of
the company?
this company, we're not told.
Nobody asked. And nobody asked.
Nobody, I didn't ask. It was wasn't for me to ask. It's for them to establish what they say.
What Mr. Kuo had actually done, is this right, was personally to encourage infringing importation.
Yes.
Of,
Yes.
contrary to IP.
Effectively, wearing a hat as a manager, he was personally encouraging proper importation. And participating in the actions of that. So it's not just encouraging.
Okay.
Well, he was responsible for procuring an indemnity against the consequences of infringement, so it's hardly surprising that Mr. Justice Pumphrey found it fell on the right side of the line.
That fell on, yes, that fell on the right side.
But he said it was a difficult decision
Yes,
on the facts.
certainly. In paragraph 23, I think this case is near the line. But Mr. Cure's close involvement with the day-to-day actions of the company and his independent authority in respect of those actions, together with the other matters I referred to above, satisfy me that he sufficiently worked to bring about the continued importation into the United Kingdom of the CDRs in question, that he is liable as a joint tortfeasor with Princo. He had knowledge of the transactions, he arranged the indemnity. He's sufficiently bound up in Prince's acts to make him liable. So arranging the indemnity was an act which counted against him, not in his favour. But as I say, I readily accept that each of these cases need to be looked at. Every case is fact sensitive. And in our case, in a sense that quite a lot of complex facts, but when it comes down to it, what was the involvement of Mr. Joannou in relation to the production of documentation which omitted any reference to risks? And the answer to that is substantial. So as I say, I think that may I turn back to looking at the judgment? That's where we left off.
Yes, of course.
I'm sorry. What one sees straight away from the lifestyle case is the significance and importance of fish and sea shepherd, as indeed one would expect. However, the learned judge in paragraph 60 puts that to one side and says, this is not a case of a joint tortfeasor ancillary to another independent party such as fish and sea shepherd. Now that is completely irrelevant. Because in fact, as we've seen, the cases show that a director can be jointly liable. In Sea Shepherd, it happened, as a matter of fact, that he was independent. But that's not a relevant reason for distinguishing Sea Shepherd and setting aside all of that learning in relation to joint liability. And indeed, Sea Shepherd is not, the principles enunciated in Sea Shepherd do not distinguish between the person who's a third party or the person who's in-house. One of the interesting questions, which were this case to go further, is whether Sea Shepherd was intended to provide a comprehensive code, as it were, which encompasses and overtakes MCA and Charlie. But I don't need to go that far. Then
lifestyle, the timing of lifestyle was such that it wasn't cited.
No, what happened was, and it's very unfortunate, I was in New Zealand. By the time that this case came out, submissions ended at the end of April, on the 30th of April. This decision in Lifestyle came out was published on the 7th of May. Yes. And unfortunately, nobody managed to pick it up.
I'm not being critical, I was just asking.
No, my lord. But and indeed the learned judge as well. But I'm not blaming anybody, but it's important. It's a really important case, I think, for the purposes of assisting the court to focus its attention in the right way. In the case of a company director case, then the learned judge says, I've been referred to the following authorities. It starts with Williams, which is assumption of liability, then goes to MCA records, Königlicher, Context Dewsbury Global, which are all cases to do with accessory liability, as well as Società Esplosivi Industriali, SPA, all to do with accessory liability. then it's not suggested that the company does not have, and he doesn't draw, unfortunately, any principles to be derived generally for each limb. But certainly from our point of view, he doesn't draw any general principles relating to accessory liability and abstains from doing so effectively by by distinguishing Sea Shepherd. It's not suggested that the company doesn't have any independent existence, nor that it's a facade or sham to cover a personal adventure by Mr. Giuanu, which would fix him with some personal liability, direct liability, assumption of responsibility. It obviously owns substantial property in Cyprus. There was no cross-examination of Mr. Giuanu in relation to the company's accounts, which there weren't any company accounts to examine him on, but I'm not sure what should be drawn out of looking at the company's accounts, to be honest. And he doesn't, the learned judge doesn't explain why that has any relevance at all. I respectfully say that it's not. There is no arguable basis for piercing the corporate veil, and we weren't seeking to do that. Even assuming all the matters set out in paragraph 59 above, and as my lords will appreciate, we say that that's a rather short, all too brief and wrongly brief summary. Though I'm not convinced that he is a Svengali, I'm not at all persuaded that in relation to the one issue which I found in favour of the claimants, the negligent failure to give advice to the claimants in relation to foreign currency risks, nor even if I had found the other misrepresentations to lettability, drawdown or ease of resale, that he undertook or had personal liability. Now, as I read that, he's dealing with both limbs simultaneously, but without distinguishing what are the features which actually...
But he then goes on to do that in the next sentence.
There was certainly no singular feature which would justify belief that he was accepting a personal commitment, as opposed to a company obligation, which is assumption of risk, nor crossing the line which conveyed to the plaintiff that the defendant was assuming personal liability. So that's William's line. Nor his participation or involvement in ways which go beyond the exercise of constitutional control, as to which he had no evidence whatever other than the evidence of Mr. Giuanu himself, which pointed to there being no role constitutionally which Mr. Giuanu was performing. So
well, that's a one-sentence finding, and you say that was wrong. And that really is your appeal.
Well, yes. I mean, yeah, effectively, yes. Because it's but what he does.
The next sentence where he says, when these claimants were induced to contract, it was with APP, and I'm satisfied, etc. You'd say none of that's relevant.
Well, that's irrelevant. It would be relevant to assumption of responsibility.
You're not pursuing that.
But we're not pursuing that. Not relevant. Notwithstanding the wording in their 2020 witness statements, what there has been, in my judgment, is an understandable attempt by the claimants who've suffered loss and distress over a period of more than 10 years to ensure a solvent defendant. Well, again, yes, maybe, I don't know. I think that's how he looked upon the evidence, but not a relevant consideration for determining. For present purposes, it's not a relevant consideration.
Stripping away
yes.
all of that and stripping away the assumption of responsibility.
It comes down to simply by saying his participation and involvement in ways which go beyond, he was not guilty of participation or involvement in ways which go beyond the exercise of constitutional control, as to which he had no evidence. So
he's considered the right test. That is, you say that is the question. So he's considered the right question.
Yes, but what he has not identified are what are the factors which he's taken into account in arriving at that.
He's considered the right test, and you say, and he's given his answer, which is that he, which was no, and you say he was wrong in that, and that really is none of it.
Yes, if one's going to put it in a sentence, yes.
So ultimately, it's a factual issue.
Well, it's more than a factual issue, because the first question is to identify what are the facts, and we say the facts which is referred to are light, he's referred to some, but he's not referred to the all-important fact that the documents don't include any kind of warning about risk.
That is the negligence that he's found.
It's the negligence which he's found. But now the next thing is that he doesn't go on to, he doesn't refer to that at all in his paragraph 59 factors. He says he's found the negligence, but then he says, well, I'm looking at these various facts set out in
He plainly has that in mind in paragraph 62, because he mentions it. The one issue I found in favour of the claim.
He mentions what he set out before in 59, but what he hasn't set out in 59 is the omission at all of from any of the materials, materials published, which he was supervising, to the members of the public. That the omission of that risk. One looks, for example, on the website. There's nothing, there's not a word about it in all the explanations extolling about the virtues of the mortgage scheme. You look in the brochures, there's not a word. It's omitted. But what the judge has not listed in his 59, in his factors in 59, is the omission itself. And then looked at the responsibility which Mr. Joannou had for what was being published. And then
it's paragraph 18 of the particulars of claim, paragraphs A to G.
Sorry,
where you
give me one moment.
Sorry, it's core bundle page.
Yes, I'm just looking for my copy.
It's the pleadings core bundle 2, page 10.
Yeah, that's gone. Would your lordship just give me 1 minute? It's just somewhere. Well, I had it a moment ago, but I don't know where it's gone. I'm sorry, Lord. I apologise.
Well, all I was going to suggest is that it seems to me that what you allege there in paragraph 18, A to G, is fairly well covered and summarised by the judge, paragraph 59. It seems to me plain that he's got everything you were alleging there in mind.
Yes. Well, Lord, first of all, well, if you're, even if we look at if one says that what the learned judge has said in 59 is a brief summary of what is said in paragraph 18, the next stage, which I complain about, is that the test which what one needs to go is, if he's assuming in my favour, had he carried out the right approach? Because we know that he ran everything together.
Yes.
If one assumes that he has found the facts of participation, that these are acts sufficient to make him liable, but for the fact that he is a director, then his participation involved in ways which, no participation involved in ways which go beyond the exercise of constitutional control. And what he does not do is then go on to look at what is the elements of the constitutional control. And that really is the nub of what I'm saying. It's central to that.
Yes. You say, as I understand it, that the things that we know and the judge found Mr. Joannou did go beyond the exercise of constitutional control.
Yes.
And that's the question.
Well, but the critical question, which the judge didn't actually really examine at all, is just called a managing director, is what actually were the elements of constitutional control, which factually, because it's a fact-intensive inquiry, go to this particular case, as to which he had no evidence at all as to the constitution of the company, All that he had was the evidence of Mr. Duano. Now, if he accepted that, then it would follow, I respect to say, that, and there was no reason why he shouldn't, since Mr. Duano knew peculiarly well something which no one else knew as to how the internal arrangements between himself and his father went. Then, respectfully, what Mr. Duano was doing fell outside constitutional control. But the alternative is that we just don't know what the constitutional controls are.
No, hang on. Mr. Nathan, you say if the judge accepted Mr. Ioanou's evidence, and Mr. Ioanou was in the best position to know what he was authorised to do and what he wasn't authorised to do, then what he was doing fell outside the ambit of constitutional control.
Yes.
And I'm simply asking why.
Because what the onus lies on the defendant to produce cogent evidence as to what is the constitutional control in the first place.
Sorry, with respect, that is not answering my question. Please focus on the question. You said, if the judge accepted Mr. Ioanou's evidence about the Constitution, and Mr. Ioanou was the only person who could tell us what the evidence was.
Right.
So we've got Mr. Ioanou's evidence that he and his father have equal directorship powers, and that he, Mr. Ioanou, was acting under the auspices of a power of attorney which his father had signed, which hadn't been produced.
Mm-hmm.
Assuming that that evidence was accepted, you then submitted to us that the judge was wrong to find that the acts that were done by Mr. Ioanou fell within the ambit of that constitutional control. Why?
Because what Mr. Ioanou says is that in relation to everything that I do, there has to be a power of attorney.
Yes. Then he says he has a power of attorney.
But not in relation to this. What he says. Perhaps we need to go back and look more carefully again at what he says. But as I read it, he does not say that he had any kind of power of attorney to do the kind of actions that he was doing internally in the context of the company. What he's saying is that I had a power of attorney to enter into contracts with third parties. In other words, dealings with third parties. I could do things provided I had a power of attorney. But he does not speak about having any power internally in terms of the function which I was carrying out, general day-to-day affairs, was being conducted in any way under a power of attorney. Does not say that at all.
Well, why does he need a power of attorney to do that if he's acting as a director? He is both a director and he is acting outward-facingly on behalf of the company in contracting with third parties, for which he requires a power of attorney. But why does he need a power of attorney to act as director?
Because in order to carry out functions of, we don't know what the Articles of Association of the company actually say as being the powers of the director.
Well, I'm sure we don't, but we can take judicial notice, can't we, that in the absence of such evidence, one would assume that a director has the normal powers and obligations of any company director.
Yeah, but he does. A company director manages a company through the boardroom. That's the constitutional control by which he operates. Mm-hmm. He then may have powers delegated to him by the board as to what he may or may not do. But we have no evidence as to that element of delegation. All we know is that de facto he was doing things.
There's a slight unreality about this in this case.
Well, Lord, what is so important, because it's emphasised that you need to look at, because it's such a narrow exception, you actually need to look at what is the delegated authority under which which is being relied on, the particular delegated authority being relied on by the defendant so as to raise the exception.
Well, only once you get past the first stage of
Yes.
the analysis.
But the
The
first,
first stage of the analysis requires either that the accessory has procured the company to do something, or encouraged or assisted the company to do something, or has facilitated the act which amounts to a tort pursuant to a common design.
yes, but what the judge did not do in his very brief conclusion is he did not say the acts which I look at in relation to Mr. Duano do not amount to the acts necessary to give rise to joint liability, but for his directorship. He goes straight for one thing and one thing only, which is to say that these do not go, his participation or involvement in ways which go beyond the exercise of constitutional control. So he's focusing not on the acts, and as I would say implicitly, he is accepting that those actions would, but for the question of constitutional control, be ones for which Mr. Duano is liable.
Well, with respect, I disagree with you.
Well,
there is no positive finding that those acts would amount to accessory liability, but for the constitutional control point. No positive finding by the judge anywhere in this judgment. But that doesn't help you.
Well, my lady, and the reason why either there is no finding one way or the other which the judge ought to have found. It was necessary as part of the stepping stones to a conclusion to arrive at a view as to what was the quality of the acts. Did they we don't have step one. One simply has step two, which is he looks to constitutional control.
All right, so I understand what you say about step two, but shouldn't we be sort of focusing on step one, since you say the judge didn't actually go there? Shouldn't you be explaining to us why it is that whatever he did amounts to procurement? I don't think you can leap to step two and say, well, we assume that the judge has somehow sub silentio made a finding that it would attract accessory liability.
Well, then may we go back to my paragraph 25 of the...
I mean, on the face of it, he has actually made a finding against you.
Yes.
My lady may be being too favourable to you, because at paragraph 60 he says this is not a case of joint tortfeasor ancillary to another independent party such as Fish and Fish. Maybe the emphasis there is on independent party, I don't know, but it certainly doesn't help you.
Well, I'm sorry, I'm not sure I think...
Well, I was just wondering whether paragraph 60 is saying it's not an accessory liability case.
But when he says this is not a case of a joint tortfeasor ancillary to another independent party, all he's simply saying is what we know, in a sense, but he's dismissing and refusing to look at the principles of Fish and Fish on the grounds that it is distinguishable.
Yes.
But what he does not do is go through that exercise. I'm very happy to take your lordship through. We've done it in our skeleton at paragraph 30. Was it? Check. Was it 25? What we have done in terms of the facts, at paragraph 24 of our written skeleton, we set out the material. And the significance of all of those acts in 24 and 25 and then we go on and the case becomes all the more strong because the judge has found that the circular was the bank circular in October 2006 was given to the defendant company around October, the early part of October, at the time when the lengthy sales agents conference was taking place in October 2006. So again, all the more so would one have expected there to be some kind of a warning given in one of the documents or another of the documents which he, Mr. Giuliano, approved, setting out the risks. And that omission is the approval of documents omitting that is the sufficient act for our purposes, for the purpose of establishing the first element of the fish and fish requirement. And as in response to my Lord Justice Phillips' point, we say that under the Sea Shepherd analysis, it doesn't matter whether or not whether the company was or wasn't a one-man company, because we're just looking at the acts of the individual as a joint tortfeasor with the company.
I think my point about the one-man band was it's rather harder to say.
Constitutional. It was more directed towards the constitutional role.
He's not exercising his role under the
constitutional role
when he is sole holder of all the constitutional positions in the company.
Yes. Now, then we look at the question of, secondly in 27, we look at the second element under Sea Shepherd, which is common design. And we say that readily one can infer that there was a common design because of doing the acts. You don't need to have in mind that the act itself is going to be a tort. It's simply a common design to do the act which constitutes the tort.
Then you'd have accessory liability in every case where the director approved the documents.
Well, it may be, my lady. It may.
That's not what Sea Shepherd is about.
Well, Sea Shepherd does not address the specific case of a director of a company.
No.
But were there to be two partners? And they both approve, they would both attract a joint liability. It's difficult to see that there should not be a sufficient act of a common design between the defendant and the primary tortfeasor, merely because the primary tortfeasor is a company, whereas the the person who is the accessory to that act is an individual. I don't think it makes any difference. And one starts off really with his master plan, which encompasses all that is then to be produced, which includes
act in a way which furthers the commission of the tort by the principal tortfeasor in pursuance of a common design to do the act which constitutes the tort.
Yes.
So approval furthers the commission of the tort, you say. In this case, in fact, it is an approval. He approves the publication of the material, which is published to the general public and to the claimants, consisting of all these different pieces of information, whether in written or in oral form, none of which contains the all-important risk warning. The fact that he did not appreciate that it was a tort is neither here nor there. Didn't consider it. So it's the act of approval that
Yes.
you say amounts to the what attracts the accessory liability.
Yes.
and one then goes on to see whether that act was done qua directa within the constitution of the company or
Not.
not.
Yes.
And you say that because he didn't have a piece of paper which was signed by his co-director, which said you may approve literature which goes out to promote the selling of this type of marketing or this type of marketing exercise, he can't fall within the narrow ambit of the exception.
Yes.
Yes.
Yes. And indeed, I say it on the basis of good authority. Can I on one element of that, take the court to the case of Ottershaw? Just if you give me very well, I just put some of these pieces. You find it in volume 3 of the courts. It's tab 38. It's a case which is cited by the court in Lifestyle. At paragraph 47, and if we go to paragraph 21, I think, it's fortunate it's quite a short case. But I think that I'd like to pick it up, if I may. Outer paragraph, and the paragraph numbers in this case are very strange. I mean, I think it's the inner ones one looks at, in fact. Paragraph 19 of the inner, starting, Mr. Hockman submitted that where the company is what he called a one-man band. There can be no common design because one cannot have a common design with oneself. But this proposition contradicts the first proposition, that the veil shouldn't be pierced, because if the veil is not pierced, then there are two legal actors involved. The classic exposition of the circumstances in which a director of a company can be held liable as a joint tortfeasor with a company that he controls is to be found in the judgment of Lord Justice Chadwick, and the court recites the first two principles. 22, the acid test then is whether the putative tortfeasor is exercising control through the constitutional organs of the company. If he does no more than vote at board meetings, then he will be exercising control through the constitutional organs of the company. The constitution of the company may, of course, have delegated authority to the officers of the company without the need for formal board meetings. And in that event, it wouldn't rule out the possibility that an individual doing no more than exercising that properly granted authority would escape personal liability. It is, of course,
what was the nature of the wrongful conduct which was an issue in this case?
This was, I read it last night, I'm afraid rather late again at night. It involved there was a lot of rubbish going on. A lot of rubbish had been piling up in a building. And
I mean, for what was Mr.
They constructed
And
a staircase which infringed.
There was a claim for declarations on a claim for a light of right, an injunction to restrain the defence from interfering with that right, and so on. And then Dr. Rahimian gave a personal undertaking to remove scaffolding by a specified date, not to interfere with the alleged right, and so on, to remove support for an external metal staircase, to reinstate a section of pipe, and so on, in other undertakings. Despite the giving of the undertakings, building work went on, although as a result, the proceedings were scaled. As a result of the proceedings, the works were scaled down, and various things went ahead. And then at 8, there was an order of the court. The defendants will be jointly and severally liable for the claimant's costs for the consolidated claims and so on. And then at 9, outer 9, inner 8, Mr. Hockman submitted the judge was wrong to have granted a mandate.
No, I'm just asking what was the wrong for which the personal defendant was being held personally liable?
And it is that the because there was the work was being conducted, as I understand it, by the company. The undertakings were being given by Scandia Care and Dr. Rahimian together. Yes, one sees that in fact it was Scandia Care, last bit of paragraph 4, last sentence, and then that's out of 4, inner 3, and the next paragraph as well. A few days later, Mr. Brown of Ottercraft instructed GKS to contact Scandia Care's surveyors. So it's the company that was carrying on the business. At outer 6, inner 5, Ottercraft began proceedings against both Scandia Care and Dr. Rahimian.
Mr. Nathan, I think the answer to my Lord's question easily apparent from paragraph 21 of Lord Justice Lewison's judgment.
Yeah.
Dr. Rahimian was responsible for the continued infringement of the interim injunction by carrying on the building and getting in the right of light.
Yes.
Was obstructed, and that's what he was held to be responsible for. Although he had also his own personal liability, one sees from paragraph 20, that he'd given a personal undertaking, he was breach of that as well.
Yes.
But the answer, I think the answer to my Lord's question is he was personally responsible for the company's continued infringement of an interim injunction.
Yes, because he was directly controlling the company. And then we go to outer 21, inner 24. In the present case, moreover, there was no evidence of what the company's constitution was, no evidence of the decision-making process within the company, no indication that Dr. Rahimian's co-director played any part in that process, and no evidence that the company did anything other than what Dr. Rahimian wanted it to do. The judge's finding at paragraph 12 was that Dr. Rahimian controlled Scandia Care. He continued, it's abundantly clear he did so, and that he was personally instrumental in pushing the plans for redevelopment through. Any act that I'm considering was an act of Dr. Rahimian, as much as it was an act of the company. To join Dr. Rahimian to proceedings is not to pierce the corporal veil, it's to bring a claim against a tortfeasor. Nothing wrong then in the next, nothing wrong with the judge's findings of fact. And that corresponds very much with what is said in the lifestyle case, that it is necessary for the defendant that the director must, by cogent evidence, set out what their evidence is. If I can just pick up on that. If we go back to 35 and to the lifestyle case. We said there. Yes, I think it really is what is said in paragraph 48 and 49 in Lifestyle, and in particular 49. Pulling things together in my judgment, MCA and Charlie represents the law on this topic in England and Wales. Protection for our director, identified in Lord Justice Chadwick's first principle, is not strictly confined merely to voting at a board meeting, but it's a narrow protection limited to exercising control of the constitutional organs of the company. although that may be something which can be delegated. A director seeking to avail themselves of that principle of delegation in order to escape liability will need to prove that that has taken place. In any event, showing simply that the director has acted properly in the sense of not acting in breach of their fiduciary duty is no defence. So the obligation lies on the director to put forward what is the constitution of the company. But if, once you've got evidence from Mr. Joanna that there is no such thing as a managing director, the finding of the judge that he is the managing director is and then with what consequences under the Constitution, it's not enough to get the director into that escape box. Because what he's got to do is to show that forgive me for one second. What do I get? Page.
It's in the 69A of the original trial. There really was no evidence. It comes down to that, really, as short and as simple as that. But if Mr. Joanna was going to run that as a defence, he needed actually to bring forward evidence which actually cogently showed that what he was doing was acting no more than in a constitutional role, and he never did it. The assumption made at trial was that the company law of sightless registered company is the same as English law. Broadly speaking, yes. But he said no. It's different in this respect. And there's this piece of evidence. I appreciate it doesn't come from one of the law experts. But again, if Mr. Joanna was going to make any point about the constitutional role or that he played and how it worked out within the company, then he could have put in expert evidence, but he didn't. So the court is left with this tiny picture that he gives, which is not a satisfactory basis for saying he has established that he comes within the narrow exception which favours directors acting within their constitutional role. Can I ask something that I'm not clear about? Yes. In all this is the distinction between someone, whether it's officer of the company or employee, being authorised to undertake acts, and something being delegated in the sense that's being talked about in MCA. Yes. Plainly, lots of employees of companies are authorised to act in particular ways, but you wouldn't say that they were carrying out constitutional functions, nor that those constitutional functions have been delegated. Absolutely. And I think the importance of the word delegate is that certain powers of the board are delegated to a director so that they do not need to revert back to the board for authority that the company shall do something. That's how I read it. In a sense, any document that is issued by the company has to be issued with the authority of the board, one way or another. One way or another, somehow. You've got to get to that.
Because the
got to get to that position. And if you could do it properly, but you haven't done it properly, you're still liable. It's not a defence just to say, well, I didn't do it the right way. I'm terribly sorry. I could have done it the right way, but I didn't. That's not that unfortunately, because of the narrowness of the principle, does not exculpate the director. He may be entitled to an indemnity from the company, but that's all quite separate. That's in between him and the company, which comes within the principle of C-shepherd, that it's then a matter of internal issues as to the amount of contribution as between the company and the directors.
It's your case, presumably, that the documents that were issued and the training that was done was duly authorised by APP.
Yeah, the evidence was, and I think if give me a moment, I think the judge actually says that they were authorised by Mr. Joannou. So give me a moment, we'll find them.
Well, in that case, your case must be that Mr. Joannou was acting with due powers delegated by APP.
Board.
No, I don't know. I don't need to go that far.
Well, otherwise the company wouldn't be liable.
No.
You've got to attribute the act to the company in the first place before you can get a joint tort visa. I think we all accept that the literature was issued for and on behalf of the company, and that act is ascribed to the company. So somebody must have authorised it.
Yes, but
It was either the board or, as you say, it was Mr. Joannou. And as my lord has said, if it was Mr. Joannou and he had the power to bind the company, he must have done so by some delegated authority.
Well, I see the point. I understand the point that my lady is making. The difficulty being this, that for the purposes of authority, a company may well be stopped from denying authority. It's something which is published in its name, and its management stands back and causes that to happen. It would be not open to the company then to say, this is not an authorised publication.
Well, you only get to a stop if there is no actual authority. Here,
Yes,
surely there is actual authority to conduct the business of the company which is developing and selling these properties.
You told us that there was a fact finding by the judge to that very
But
effect.
at the end of the day, what is it is deliberately and narrowly so framed by the Court of Appeal, by Lord Justice Chadwick, is that you have to demonstrate, and indeed it is as shown by this recent case, that you have to demonstrate that there is actual a delegation of appropriate authority to do it. How in the name of the company.
But isn't that? But does that need to be done if your very claim against APP is that APP did these things and that you say Mr. Joannou procured them? So Mr. Joannou must have done so with the authority.
We don't need at this point to have to try to trace back now what was it that was the authority of the company to issue this material, because we know that it did. The judge has made findings which, as to that, which are not challenged.
But it's your, forgive me, but I see that against APP. But now,
Yes.
can you have your cake and eat it?
Well, I can. I think is the answer.
You haven't heard my question yet.
No.
What I can say is, can you both say that these documents were issued by APP, and then say, and the only person who was controlling, masterminding it all, and procured that be done, didn't actually have the delegated authority of the board to do so? Seems to me that is abrogating your initial proposition.
Well, no, I don't. Well, I respectfully disagree with my lord. As your lordship would no doubt expect me to do.
No, I'll give you a chance to answer it.
Yes. So far as the action of delegation to Mr. Joannou is concerned, that's a formal act which, so far as personal liability is concerned, it's necessary for him to show as regards himself personally. So far as the company is The court is entitled to infer that the company, and indeed there is no issue, no, sorry, it's not fair, that there was an issue as to whether or not the bonds were in fact issued by the company. But the judge found that they were issued by the company. But the fact that the person who authorised them may have acted beyond his authority, I don't know, because there's no suggestion that he was acting in any way beyond his authority, because he never contended that it was not within his, it was beyond his authority. This is, I mean, the difficulty in a sense is that we are always going to face, in a case where there is an accessory liability of a director, where there are actions done by the company as the primary tortfeasor. And usually because there is a manager who has done them and who's held out to the public as having the authority to do it. And the company does not stand back and say, no, he hasn't got any authority. But when it comes to the question of the personal responsibility and the personal liability as an accessory, then the court actually demands, or the policy of that's involved behind the principle is that it requires the director personally to identify what is the source of his authority, so as to exculpate himself from personal responsibility for acts done by the company.
But that's a composite case, which it seems to me you haven't advanced.
Well,
Enough to stop you saying that Mr. Joannou is personally liable for this tort because he wasn't acting outside, wasn't acting with constitutional authority. Therefore, he didn't have constitutional authority to issue these documents and carry out the training, etc. Nonetheless, APP is liable because he had ostensible authority, and or the company ratified or whatever the document. But that's not the composite case you've made. You've made the case that these were APP's authorised documents,
yes, and
that they were issued at the direction or procured by its director, Mr. Joannou. And the inference one draws from that, surely, the presumption that everything is done correctly. I won't try and pronounce the Latin maxim. Would apply, and it seems to me that, in a sense, I mean, you very much put this on the basis that the burden is on the second defendant, but it may be that the way you put your case means that, in fact, the burden is on you to show that it wasn't done properly.
It being an evidential burden rather than a legal one.
Well, no, because I think that the paragraph 49, which when we looked at it, says that he will need to prove that has taken place.
On the facts here, hasn't the judge effectively found, and isn't it anyway the case, that the documents in question were all issued by the constitutional organs of the company responsible for the marketing of these properties? That seems to
I just
me
think
to be
that
a
may I
fair way to
think
put what
think
happened.
that over for a second, my lord. Lord, yes is the answer. Issued with the authority of the company. However, it's the role of the individual, and we know that was a tort. The next question is whether the director engaged is personally liable, and he can only escape liability personally for participating in the tort of the company, provided that he can show that he himself had a personal constitutional role, which he was fulfilling.
He doesn't need to do that if the judge has already found that that was the role that he was fulfilling in order to bind the company, and that's the problem.
Well, my lady says that's the problem. Well, I hope that the way I explained it says that indicates that it isn't a problem, but it's two different aspects or two different facets of the same set of facts. Yes, but you actually have to look at them as quite separate.
I don't understand why. You've got a fact finding by the judge that this is duly authorised. If he found that it was implicit authority or ostensible authority, it might be a different matter. But if it's actual authority, and the person who's the agent or the organ of the company for the purposes of the actual authority is Mr. Ioannou, then you can't say, on the one hand, he had actual authority to bind the company, and on the other hand, he didn't have actual authority when he was doing the very acts that bound the company.
Well, I'm not sure that the judge addressed himself to the question of actual, ostensible, implied, or whatever authority by which these documents were issued, because he found that they were issued by the company. Now, I appreciate the concept of a company is an artificial construct, but it is a separate legal personality. It's always going to be a problem when one is looking at cases of the accessory liability of a director, that there's
well, not necessarily.
difficult to create that divide.
Not necessarily, because you may get a case where you've got some evidence in relation to the board authorising a general activity, and then you've got a particular director who wants to get himself within the narrow exception, who's gone off on a frolic of his own, if you like, who can't show that he's simply acting within his constitutional rights, because whatever he's done is something that would actually require board authorisation or delegated authority.
Mm.
But that's not this case.
Well, but here he does need to show that he personally had a delegated authority.
So you say.
Right, well, I see it's 1 o'clock. How much longer do you think you're likely to be?
Not maybe 20 minutes or no such thing.
Right. Okay, that's very helpful for everyone to know, especially Mr. Parker. 2 o'clock.
All right.